And of course, he had no intention to do it and didn't do it. So what Verna was horrified by was that he would lie to his mother on her deathbed, and she really was put out by that. So she told me about this, and I knew her quite well. And she was a figure around Washington, an amateur writer, a nurse, and various things. You have a lot of people floating around Washington like that. And so this is what they were referring to, Verna's connection with Hoover. And I said, well, no. I said, you've been misinformed. I said, go back and get me some more information, and maybe I could talk to you. But they were so relieved to know where I was, because J. Edgar Hoover was going out of his mind, wondering what happened to me. And they left immediately, and of course, radioed in that they'd found me and all that. But I didn't know what was behind all this till later, till I got my file in 1982. This was in 1959. So after I got my file, and I had 40 pages of memoranda from J. Edgar Hoover and FBI officials about committing me to a mental institution, which is about as big an invasion of privacy as you can have, even if I was crazy, which of course I was writing books like crazy, and I wasn't showing any mental aberrations of any kind. And so I filed suit against them, and I didn't know it at that time, but the government has a policy when you sue them of not answering, of deliberately going into default. Because under the court system, they figure you can't do anything anyway, you'll get a default judgment. And under federal court procedures, a judge does not enter a default judgment. You, the plaintiff, enter the default judgment. So I went to the clerk of the federal court with my default judgment for $35 million was the first suit, and entered it, and it's been on the books ever since. Never challenged by the government. So a little while later, I thought, well, I need to sue them again, so I sued for $50 million on the same grounds, and since the other had not been adjudicated, see, when a case has not been adjudicated, you can always reopen it. I'm reopening a case in Massachusetts where I was, summary judgment was decided against me a couple of years ago. And I got to thinking about it, and I decided to reopen it, so I filed a petition to reopen. And under our legal system today, the lawyers have set it up so no case ever really dies. You can keep a case going the rest of your life. And it costs you nothing, because once you pay the filing fee, everything else subsequent to that is covered by that fee. So you can file as many motions as you want. You can make as many court appearances as you want. There's just no limit to it. And you're in command. That's why I say be a plaintiff. By being a plaintiff, you totally direct the course of the case, how long it's going to last. You can always voluntarily withdraw the case if you feel like it. But it's up to you. And the defendant is always at your mercy. So here I had the FBI absolutely would not answer. They went into default on the $50 million. So, and I filed the default judgment on that. So I now had default judgments against the government for $85 million. And people gave me advice on what to do. One of them said I should put a lien against the White House and charge the president rent for staying there, which I very well could. But what I wanted was the Library of Congress. That was my old stomping ground. And I was going to file a lien against the Library of Congress. And I still might do it. Because and all these things are open to you when you're a plaintiff. And these are also alternatives which your lawyer will never suggest to you and would stop you from doing, just like they stop you from countersuing. Why does the lawyer do this? Because the lawyer is your worst enemy. He's an officer of the court, which means he's subservient to the court. You hire the lawyer and you pay the lawyer, but the lawyer is an officer of the court, and he has to be respondent to the will of the court, has to be respondent to the bar, which he's a licensed member, has to be responsive to the judge and to other lawyers. So it's them against you. You're always the outsider. I don't care how you come in, how much money you spend, you're always the outsider, and your interests are the last to be considered. Now, one of the most revealing things about the legal system is what's called ex parte judgments. Ex parte means without the parties. Most legal work does not appear in the courtroom or happen in the courtroom. It happens in judges' chambers in secret meetings between the lawyers for the parties and the judge. They sit there, and you're not present. They sit there and decide what to do with your case, what to do with you, how to divide or award your property to somebody else, anything. It's all ex parte. You know nothing about it, and you're advised of it some later. Sometimes they don't even tell you what they've done. But ex parte judgment shows the Babylonian system of the court system. It shows Freemasons meeting privately to make a Masonic judgment on your fate. And they will not advise you. They will not tell you anything on this. And you find out the hard way when some judgment is rendered against you, and you wonder, how in the world did they ever come to this totally unjust judgment? They came to it as a conspiracy. It's a conspiracy against you, and you're the victim. And you have little recourse. You call up your lawyer. He doesn't return your calls, by the way, and complain about this. And you can call him for weeks, but you'll never get a response, because what's he going to say? Look, we double-crossed you. That's all he can say. That's his only defense. But by representing myself, you see, I short-circuited the whole system, and that's what you do. So no matter how unprepared you are and how scary it is, believe me, when I first went to court on my own, I was pretty nervous. And a friend of mine who was a lawyer was sitting there, and the judge looked at me and he said, do you want to file a motion? Well, I didn't know what a motion was. I'm sitting there on the lawyer's bench. When you're your own lawyer, you sit up with the lawyers, and it's strictly forbidden for anybody else to sit there. So I'm sitting there on the lawyer's bench, and the judge says, do you want to file a motion? And I had no idea what a motion was. And so this guy came over and said, he wants to know if you want to file a paper. I said, oh, yes, I'll file a paper. I never did, but anyway, I agreed to do it. So that was the only help anybody ever gave me in court. Now, the American Bar Association states specifically that when you represent yourself, the judge has an obligation to step in if you are at a loss as to how to proceed or what to do next. The judge is supposed to advise you. Do you know what happens in an instance like that? The judge says, I am not allowed to give legal advice. And that is an absolute lie. He's obligated to do it. But he says, I am not allowed to give legal advice. And I have never had a judge help me in court in any way. Except one time. The other side, because you're representing yourself, what they hope to do is to stick you good by not only ruling against you, but then awarding attorney's fees to the people you're suing. And they can stick you for $30,000 or $40,000 attorney's fees. So I had sued the city of Stanton on a case where a guy ran into my car and tried to kill me. He was assigned to kill me. And he came at me with a big Lincoln and hit the side of my car and smashed it in. But I had a big Oldsmobile, which was just as big as this car. And all it did was dent the door. Didn't hurt me at all. And so then he got out and said, he said, look, my insurance will take care of everything. And he drove off. Well, he called the police, and then he drove off. So the policeman came up on his motorcycle, and he was a big, mean policeman, one of the meanest policemen you ever saw. And he said, where is Mr. Snyder, the other guy? I said, well, he drove off. He said he couldn't sit around here waiting on you all day. If you were so slow, he was just going to leave. And, of course, the policeman turned flaming red, and I said all this very innocently. I was trying to be nice, help him out. And so the policeman, of course, then became my chief witness. And the case dragged on. And finally, we were ready to go to trial. And we were going to go to trial on Monday. On Friday night, this policeman was taken, a big healthy guy, was suddenly taken to the hospital with some ailment or so, and died within minutes after getting to the hospital. So there went my witness. And I'm sure they murdered the guy because, as I say, I had an open and shut case. He had run into me. The guy had left the scene of the accident. Everything was going for me. And but without him, I was alone at the time. I had no witness of any kind. So we went ahead and had the trial. And so at one point, the jury went out to look at my car. The side was smashed in where he had hit me from the side. And the jury came back and deliberated 8 minutes. And of course, they had the jury stacked against me. I didn't know that. They always put somebody on the jury. So the jury deliberated, and they came out with their conclusion that the accident had been my fault, that I had backed into him. Now, how I backed into him and smashed in the side of my car, they didn't explain. But they ruled against me. And I didn't even appeal it because it was so ludicrous. I had had my fun. The case had lasted almost 3 years. So I had had my fun anyway. Oh, by the way, they also brought out during the trial, during the discovery, that the guy that ran into me was legally insane. He was under a medication for insanity, which affected his driving and so forth. So I had everything going for me, but the jury ruled against me. That shows you the importance of a jury trial. But that was just one of my experiences. But I have had some great experiences in court where I absolutely destroyed the lawyers and put them to shame before the court because they screw up a lot. And in fact, I always had a lot of fun with my law because being a researcher, I love to use the Oxford English Dictionary. And the Oxford English Dictionary is full of citations in Old French and Middle English, which of course are totally undecipherable to anybody in the world. And I put these long quotations in. And it drives the lawyers crazy because they don't know what it means. I don't know what it means either, but I don't tell them that. And so finally, a couple of lawyers went before the judge, and they also complained that I was putting Latin statements in my briefs. Well, Latin was the original language of law, you see. And so the judge agreed, and he ordered me to stop using Latin quotations in my brief. Order from the judge. And so I obeyed it for a few weeks, and I started putting them back in, and nothing was ever said about it. And but this is just one of the things that I did, having fun in law. But the lawyers themselves, they're very incompetent. Now, even Chief Justice of the United States, Warren Burger, appeared before the American Bar Association about 20 years ago, and he chided them. He said, you know, 30% of all lawyers in the United States are totally incompetent. Because he was complaining, because as a Chief Justice of the Supreme Court, they saw cases come in that were poorly prepared, had the wrong citations, and this is very annoying. The Supreme Court's a very august body, and to have this junk coming in and presented to them as arguments, it was very frustrating for them. So he told them that, and I would say today it's up to about 50% because they're getting worse all the time. You know, lawyers are not taught any law in law school. I had a lot of fraternity brothers who were law students, and they deliberately don't teach them anything because the law firms that hire them, when they get out, they don't want them to know very much because they want to indoctrinate them in that firm's proceedings, the way they do things. So they come in with a clean slate, and they become very good members because they learn to do what they're told to do, and they do things just the way that law firm wants done. So a graduate lawyer is a guy that doesn't know any law. My niece married a guy who was going to University of Virginia Law School. Of course, I had lots of action going at that time. And occasionally I would ask this guy, Dean, I'd say, I'd see him at my brother's house, and I'd say, by the way, Dean, I've got a motion on this, so what do you think about it? And he would give me a blank look. He hadn't a clue as to what I was even talking about. And I found this very strange. Here's a guy, a law student at one of the best law schools in the world, and he doesn't know anything about anything, and still doesn't probably. He went into commercial law and made a lot of money in real estate. But he himself agreed he would never practice law, and he never did. He just went into a very specialized field and did very well at it. He worked hard, but he made a lot of money, making $1 million a year now, and one of the best law firms in the United States. But he still doesn't know 1/10 as much law as I do because he never practiced law. How do you get to know law if you never go into it? I don't think he's ever been in a courtroom. But one of the greatest treats that I had was once a month, the judge of the court will have motions day in his chambers. And the lawyers from all over the state come there with their motions, and they argue the motions. And the other side argues against it. And it's very cut and dry, very perfunctory. You're in there a couple of minutes, you read your motion, I want so-and-so. The other side says, no, we won't, we oppose that. And the judge then gives a decision. Well, when I went there on motions day, I would have motions that were 10, 15 pages long, and we would sit there arguing these motions. And here you had $400 an hour lawyers piled up outside all the way around the building, right? And thousands of dollars going to waste while I'm in there arguing these motions. And I didn't realize what an obstruction to justice I had become. because all I was doing was, arguing my own case. And so finally, they tried to frame me by seizing all of my property. Oh.
Your hand.
Oh, I'm sorry.
All righty, you're on.
All right. Now, the history of law in the United States is very interesting because it was a very simple profession up to 1900. You only had one law book in the United States. It was called Kent's Commentaries, and it covered everything, and that's the only law book that lawyers needed to know. And there weren't many law schools. Most people read law in another lawyer's office. And all you do is sit there and read Kent's Commentaries and go with the lawyer to court and see how he argued his motion and so forth. So that all changed in 1900. And what happened was, with the Eastern European immigration, the American law courts switched over, and I'm sure the Canadian courts too, they switched over from this very simple, basic law to Talmudic law. Now, Talmudic law comes from the Kahila, and it's a totally different ball of wax. Has nothing to do with human rights, has nothing to do with justice. It's simply a mechanized system for imposing the will of the court on the litigants. And that's all it does. It imposes the will of the court. And that's why they brought in the process of discovery, that you had to turn over all your papers to the other side, total violation of the Constitution, and totally illegal, because what they would do is try the case through discovery. In other words, the opposing lawyer would go through your private papers, pick out what he could use against you, and go to court with that, and he would have a very good case. So the jury never got to hear the evidence. In fact, I gave due notice to the court in Massachusetts, where I have a case going for 10 years. I do a lot of civil rights cases because, I'm standing here talking before you. This doesn't happen very often because a lot of times when I am going to give a lecture, and they announce it and on the radio and the papers and so forth, by the time I get there a couple days later, someone has organized a tremendous campaign to prevent me from speaking. The lecture hall has been taken away. There's always a front page newspaper story denouncing me, and because I am pretty dangerous. J. Edgar Hoover called me the most dangerous man in America because I was dangerous to him. He was absolutely right, but I wasn't dangerous to anybody else and never have been. But he really considered me a real threat. And the strange thing was that during the years that I was, that J. Edgar Hoover had me under daily surveillance for 33 years, I spent all of my time in Washington at the home of a high FBI official who was an old friend and a great admirer. He was also a great admirer of J. Edgar Hoover. He thought he was a great guy. But finally, they called this guy in and they said, well, of course, we know that your friend Eustace has been staying at your house, and he was only about 8 months from retirement. And they said, if you let him back in your house once more, you will never see your pension. And the guy didn't have that kind of money. He needed his pension to retire on. So he asked me to meet him downtown, just beyond the Justice Building. And he said, Eustace, I've got some awful news. I said, what? He said, well, they've told me that I must break off all contact with you until I retire. And he was so shamefaced, because he was a very honorable person. He was so shamefaced about this. I said, well, H.E., don't feel bad about that. I said, this is not your decision, someone else's decision. I understand that, and I certainly don't criticize you for it. And so he was very relieved, and I said goodbye, and I didn't contact him until he retired. And after he retired, I went back to staying at his house because he was getting his pension, everything was taken care of. But this is the kind of bureaucratic dictatorship that you have in Washington. Total subservience to, it's like military discipline, really. You cannot criticize your superiors. You cannot go over the head of your superiors. Your whole career is passed under this discipline, and at no time can you ever go beyond it. If you do what they call the whistleblowers, if you become a whistleblower, you become immediately the most hated person in the area. Like Ted Gunderson told me yesterday, he was kicked out of the Association of Retired FBI Agents, which all FBI agents belong to, and which is considered a very good society to be in, and they're proud of being FBI agents, and they're proud of being members. They kicked him out because he criticized some things the FBI had done. And so that's no reflection on him, that's a reflection on them. And I think he told you, too, standing here, that his former associates in the FBI were spreading rumors that he was homosexual, that he'd embezzled money, and so forth. This is standard procedure. They do this. In fact, at one point in my 800 pages, they stated that I had homosexual tendencies. What they were, I have no idea because they didn't elaborate, you see. But so I'm still in the dark on that. But the worst thing that they said against me in the 800 pages was that Eustace Mullins is a very sloppy dresser. Now, it cost them $2 million to find that out. All they had to do was find out I bought all my clothes at thrift shops, and of course they don't usually fit well. They don't look that good. They're okay. They'll keep you warm, but they don't look that good. And they used to take pictures of me. I'd be walking through a yard, and somebody would jump out of the bushes and take pictures. So I figured, well, this is my publicity agent. You know, I can't complain. So they had lots of pictures of me. They always had my current license plate file. They say Eustace Mullins, 49 Plymouth, license so-and-so. And I'm sure they thought that I was a real sort of intelligence agent myself, or an espionage agent, because I had a Virginia driver's license, and I lived in Chicago, and I had a Kentucky license plate. Well, the reason I had a Kentucky license plate was you could get a license plate in Kentucky for $3 through the mail, and in Chicago they were $15. So it was simply a matter of saving $12. I mean, I had no particular association with Kentucky, but a lot of people used to do that. They would buy all their state license plates from places like Alabama and Kentucky for $2 or $3, and in New York and Illinois they're $15 or $20. So every little bit helps. And so there's always a very mundane explanation for these things, but the FBI like to think there was some sinister conspiracy in my driving on a Kentucky license plate. And this is what their work consists of, mostly is details like that. And so anyway, I finally pretty well straightened out things with the FBI because I went to court and got my judgments against them. And after that, they pretty well let me alone because the bureaucrats don't like to lose. And I had trouble with the IRS for years, and they would call me in for an audit and that sort of thing, and then they would say I owed a couple $100. So finally, I went to U.S. tax court, and all of my friends would tell me, don't go to U.S. tax court because the judges are all ex-IRS agents. So I went on to U.S. tax court, and well, first I sued the IRS because I got a notice from the IRS that they were calling me in for an audit and to bring all of my papers down to the IRS office. And so I read this over, and I thought, well, this is a very frightening thing. It's really terrifying. So I filed suit against the agent for $350,000 for terrorism. Well, nobody had ever done this. So the district director of the IRS, he immediately told my friends, he said, they asked him, oh, his cousin took him out to dinner, and she said, and she was a friend of mine, she said, what's this about Mullins suing you? He said, oh, everybody knows Mullins is crazy anyway, so don't pay any attention to it. We don't pay any attention to it. Well, they finally ruled that I had a tax deficiency after about a year. And meanwhile, I had filed motions before the court to suspend all income tax collections in the United States until they decided the very important legal points that I had brought up. Well, they didn't want to suspend income tax collections, so they didn't do it. And I thought this was a logical thing to do, because if they're stealing from me, why should they continue to steal from everybody? I'm a very sympathetic person. I like to help other people. I thought, just let everybody stop paying taxes till we resolve this situation. It's a legal matter anyway. So they didn't agree, and finally a federal judge ruled that I had a tax deficiency. So I immediately filed with U.S. Tax Court. And I was corresponding with the lawyers from the IRS. The head lawyer of the IRS assigned all the papers to me, Malcolm B. Morton. So after about a year of corresponding, finally we were scheduled to appear in tax court. And I thought, well, now I'm going to finally meet Malcolm B. Morton and see what kind of a guy he is. Well, when I went to tax court, I looked around and there was nobody there. The IRS would not send anybody into court against me, because I had filed a stipulation with the tax court judge that I wanted the IRS charged with conspiring to put me in a mental institution, because in my FBI file, they had papers that J. Edgar Hoover had ordered my income tax returns from the IRS and so forth, which showed conspiracy. So they weren't about to get into that. So when we went in, and the judge was a very stern-looking guy, and he called the case Mullins versus Internal Revenue Service. And I stood up and I said, Your Honor, I said, before we begin the case, I think we should review the stipulations that I have before the court. And he looked at me and said, Mr. Mullins, this court does not have time to go into all that. And of course, I already knew there was no IRS lawyer, and they had a little U.S. attorney there, a young guy. And he said, I want you and attorney so-and-so to go into a conference room, and I want you to work this out. So I said, okay. And so we went into a conference room, and I had prepared a long list of my expenses, gasoline and meals and so forth, over the last 3 years. And I'd done it in all different color pencils and inks and so forth, different pieces of paper and all this. So it looked very good. So he looked at all this. I worked at it, you know. I want to do things right. And so the U.S. attorney looked at all this, and he said, well, he said, actually, he said, your deductions do exceed your tax deficiency. And I didn't have one receipt or anything for all that. All I had was these papers that I had scrawled the night before, sitting while I was watching television. So we came back out before the tax court judge, and he said, have you gentlemen reached a decision? And we said, yes, we have. And he said, what is your decision? And the attorney said, well, we have found that Mr. Mullins has no tax deficiency. So I walked out of that court with a signed letter from the U.S. tax court judge that I had no tax deficiency. I reprinted it in a couple of my books. It's in Writ from Orders, and it's in Rape with Justice. And that was in '82, and I have never heard from the IRS since.